So, good evening, everyone. I am attorney Veronica McClendon, and it is my pleasure to be here with you all today. I am the CEO and the managing attorney of McClendon Law and Consulting, and I love talking to people about estate planning, about wills, trusts. And the reason why I enjoy it so much is because I believe that estate planning is one way that everybody, no matter who you are, everybody has an opportunity to make a difference in the lives of someone else, to improve their communities, to make the future better for someone else when they put some time into estate planning. And so that is the foundational principle behind everything that I do. I want to help each of you to be more mindful about things like wills and trust and setting those items up so that you can make the biggest impact possible. It's the first day of spring, and I am so excited about the first day of spring. It's a little cold here in Georgia. If you're not in Georgia, maybe you're not enjoying this cold first day of spring, but I'm excited about it. I was doing some research on the first day of spring just because some people are get a little bit more excited about it than others, and I wanted to see what was the big deal? Why are people so excited about the first day of spring, other than the fact that it is when the weather is getting warmer? And I saw that historically, a lot of people see the first day of spring as a time of refreshing. They see it as a time of cleansing. They see it as a time of new beginnings. And I thought, what a great time to do this webinar because we are talking about how to create a legacy. And I believe that if we can approach this spring season as an opportunity to have a new beginning, it's also a way for us to kind of refresh our perspective on our legacy, on the things that we want to accomplish in our lifetime, and the things that we want to put in place for those that we love and care about. So, with that being said, we're going to go ahead and I'm going to share some slides with you, and we will talk about your legacy in the making because this is really about you. It's not about me, and it's not about anybody but you and the impact that you are able to make on this earth. So you can just bear with me while I get this shared. All right. So, again, as I mentioned before, I am attorney Veronica McClendon, and I'll talk a little bit more about my firm. I'm so grateful to have all of you here. I love talking with people about these topics, and I'm hoping that once I go through some of the information that I have, that you'll have some questions, and that this can be a conversation for us all. I want it to be engaging, so even if you don't have any questions to share at the end, feel free to put something in the chat if you want to talk to us that way as well. I have this quote here from Jim Rohn. He's deceased now, but he was an entrepreneur and an author. And talk about legacy. I learned about Jim Rohn a few months ago, and he's been gone since 2009. But I listen to his talks very frequently because they're very inspirational to me. They help me to think more clearly about my goals, and I listen to him, and so I think about him as an example of someone who left a legacy and whose legacy is ongoing, and is able to have an even broader reach because of YouTube and the way that we record things these days and are able to reshare them. So his legacy has an even broader impact for that reason. But even just thinking about just in terms of this quote here. He said that the major key to your better future is you. And so, not just when I see this quote, I think about the actions that we can take today that can make things better for ourselves in the future. But there are also actions that we can take today that will make things better for those we love in the future. So, just a little bit about me. I live in Macon, Georgia, with my husband and my two daughters. Graduated from Mercer University and Duke Law School, and I've been practicing now for going on 15 years. I need to fix that. It hasn't been 15 years yet, but we are getting very close to that 15-year mark of practicing law, and I'm just I love it more and more every day because I get a chance to learn more about what it's interesting to me. I get to refine my skills and I get to learn more about how to better serve my clients, which is like the highlight to know that I can better serve my clients with more experience under my belt. I didn't always start out this way, but I have come to focus on estate planning, probate, heirs property, and farm business and succession planning. I've been doing that now for 7 or 8 years. I guess you can call it my niche. And I love talking about these topics, and people have been asking me to speak. And so each opportunity that I get to speak on these topics is just a blessing to me. A little bit about my firm. We provide heirs property, estate planning, and probate legal services to help farmers, landowners, and other legacy driven individuals build wealth, increase their income, and secure their legacies. That's what we want to do. A lot of times, you think of a lawyer, you think, okay, I want to get this specific thing done. I want to get my will done. I want to get a trust. I need to probate this estate. But when I'm working with my clients, my goal is to help them to put those specific goals within the bigger picture. We're not just doing a will just to do a will. We're doing a will because you want to leave something behind that's going to be a blessing to someone else. And so I like to make sure that that is part of the conversation as we are working with our clients in various legal capacities. Some of the things we help our clients to do: create a plan to transition their assets that accounts for probate assets and non-probate assets. And so what we mean by that is there are some things that go through probate court that your will address if you had a will. But there are some things that a will would not address. There are some things that would not go through probate court. And we try to help clients to have a comprehensive plan that accounts for both of those components. We want to help our clients provide their families with guidance to ensure that when they have prepared a will or a trust, that the process of administering their estate is as smooth and stress-free as possible. We want to also help families to transition unproductive property to make it income producing, so that they can leave more to their loved ones. So a lot of times when you go to someone to get a will done, and I would say it's becoming less and less the case these days because more attorneys are thinking about very more comprehensive planning. But a lot of times, the traditional approach to estate planning is, okay, what I have, I'm giving it to the people who I'm leaving behind, and that's it. There's not really a lot of thought about how to best transition that asset to the next generation. If I have a house, do I really want it to go to my 4 kids equally? Or is there a way that I can leave it to them so that they can actually benefit from it and not just have a house that's hard to sell, that's hard to rent, that's hard to live in because 4 people have to be in on every decision that's made concerning that property. And so that's one of the things that we want to do is help families to create plans that help their loved ones to maximize what is left behind. But we also want to help clients who have property that's not being utilized to think about ways that they can generate income with that property so that they can have more to leave and more to benefit from for themselves as well. So the context that we're having this conversation is the context of estate planning. And a lot of people, there are a lot of misconceptions about estate planning. Some people think estate planning is only for wealthy people, is only for people who have a whole lot of land or a whole lot of money or a whole lot of stocks and bonds. Those folks do need to have estate plans, but it's for everyday people like us as well, people who may not have a huge amount of assets. At least, for me, I'm saying for me now, because I do plan to have more. And I'm hoping that you are as well, that we're all thinking of growth in terms of our estates. But it's not just for the super rich or the super wealthy, it's for everybody because everybody has something that they own. And if you're an adult and you have anybody who depends on you in any kind of way, you want to make sure that you leave things to them in a way that they actually can benefit from it. So an estate plan is a person's written instructions for how their money and property should be distributed after they die. It also includes instructions for providing for and caring for your minor children or other individuals who are dependent on you. So a lot of times people are caring for an older parent, a parent who is aging and may even be dependent on their children for just everyday care. Your estate plan can address what happens with that person. If something happened to you, who's going to continue caring for your mother if she's dependent on you for care? Or if you have a sister or a brother or a cousin who is disabled and you are caring for them, who's going to take over their care if you are no longer able to do so? And finally, estate planning also includes making healthcare and financial decisions for a person while they're still living, but they're unable to handle their own affairs. So, estate planning in general, it involves passing on those personal assets, your house, your car, your bank accounts, your favorite jewelry, whatever it is that you own that's your personal property. It includes that. And when I say personal property, I'm including real property in this situation as well. So that will be real estate, houses, commercial buildings, land. If you it's estate planning also includes planning in the event of incapacity. So if you got to a position where you were unable to care for yourself, who would be in place to have legal authority to care for you, to make legal decisions for you, and to make sure that everything that you need is taken care of? It includes providing for loved ones who depend on you. We talked about that previously, and then planning for long term care. That's a topic that a lot of people don't really think a lot about. How do I pay for care if I needed to go to a nursing home or if I needed to um, have someone come into my home and care for me? So, estate planning includes that as well. And if you own land or you are a business owner, you may need a little bit more planning. You may need to have a plan in place to pass those business assets on. And you might need a plan to pass on your business operation, how your business runs. And then that knowledge base, passing that information on as well, that intellectual property, those proprietary processes, or the way that you do things. Some of those that could be considered property, and you want to make sure you have a plan in place to pass those items to the proper people who can continue to operate your business or manage the land that you're leaving behind. And y'all feel free to put questions in the chat if you have them, or if something's not making sense, let me know, because this is an interactive. I'm here for y'all, here to answer your questions and explain things as much as I can while we're here. So a lot of times people are like, okay, so what goes into an estate plan? Can you explain the documents to me? We'll talk about that now. So the documents that are included with typical estate planning, your will, you may have one or more trusts involved in your estate planning. You may have a business entity where you'll have some documentation associated with the business entity. Advanced directive for healthcare that deals with your medical care, who makes medical decisions for you if you're not able to. Financial power of attorney, who has that authority to make financial decisions for you. Life insurance, other benefits, making sure that there's proper beneficiary designations and that those assets get to the right people. And then also making funeral arrangements can be included in your estate plan. We're going to talk a little bit more about wills now. So the first question, what does a will allow you to do? A will allows you to distribute your assets. So those are the things that you own. It allows you to nominate an executor. And I always recommend having someone who's your first executor, then you'll have your successor executor, and then you have another successor. I like to put backup plans in place because you never know who's going to be around when it's time to probate your will. And you never know who's willing to serve. They might have been willing in 2024, but then you call them in 2044 and they're not really up for the job. And so I always recommend that people nominate multiple executors in their will so that they can have a backup plan in place in case the first choice is not able to serve. And you also can fund a trust with your will. That means that you can say, I'm not creating a trust right now, but after I pass away and my will goes to probate, I want to have trust created. And a lot of times that will happen when someone wants to leave things to a beneficiary who's currently underage. So, for example, I have a 9-year-old and a 5-year-old, and if something happened to me, I would want to leave things to them in a trust so that there's someone in charge of whatever I leave to them. But I don't know if they're going to be minors when I pass. I pray that they are not. I pray that they're old and that I have grandchildren and great grandchildren. But just for planning purposes, you don't know if they're going to be adults when you pass. And so you might leave it to them in a trust that says if they are under a certain age, it goes to them in a trust. But if they are over that age, it can go to them outright. And you can kind of let the decision be made at the time that the will is probated instead of having to create that trust while you're living and you don't know what the future is going to hold. If you have minor children, like I said that I do, you might also have a will that nominates a guardian and a trustee for your minor children. The guardian is the person who is going to care for them, make legal decisions for them, and essentially be the substitute parent. And the trustee is the person who manages their money. They may be the same person or they may be different people. And the same goes for someone who you're caring for who may be disabled and unable to care for themselves. You can nominate a guardian for them or a trustee for them in your will. And then finally, if you are someone who gives financially to a nonprofit and you want to continue that legacy, then you can do that through your will. I see I have a question in the chat. And someone asked if I could share information on clearing title to air property and potential operating agreements. So we'll talk a little bit about that. I might have some slides that kind of lean toward that, but I'll keep that in mind for sure. And it might be a different conversation webinar in the future, and I can make sure I do that for one of my upcoming webinars. Because what we're talking about today is really the pre-planning. What we're trying to do is prevent heirs property from being created. And so this estate planning conversation helps us to think through strategies to prevent heirs property from being created. Or if you already own heirs property, how to make sure that what you do own in that heirs property gets to clearly designated individuals. So for example, you might be one of 10 owners with heirs property, and usually it's like one of 50 or something like that. And so whatever your part is, your 1/10 or your 1/50th part, if you can clearly say, well, I don't know about the rest of this, but as far as my part is concerned, I wanted to go to my son Joseph. You can say that specifically in your estate plan so that when it comes time to clear things up, they don't have to try to figure out who your heirs are. They'll know very clearly from your estate planning who you wanted your interest in that heirs property to go to. So that's what we kind of cover here today. But as far as clearing up the ownership, we'll see if we can have some time to talk about that in a few minutes. So this slide goes a little bit more in depth about what your will can do, distributing your assets. That's your home, land, other real estate. If we have bank accounts, that could include money from bank accounts, personal property such as vehicles, jewelry, furniture. If you have property such as life insurance policies, pensions, or retirement benefits that have a beneficiary designation, in most situations, those will not be impacted by your will. However, if you don't have a beneficiary, then your will might control what happens to those life insurance benefits. So I had a case recently where someone had a life insurance policy with their job, and when they died, they did not have any beneficiaries listed. And so the insurance company reached out to the executor of the estate and said, hey, this person had life insurance, a life insurance policy. They did not have a beneficiary designation. Can you help us to get this to the right people? And so we were able to have the life insurance company make the check payable to the estate of this particular person. And now all of the people who are who are beneficiaries of the estate or heirs to the estate, they will get the life insurance proceeds. And usually you don't want it to go that way because you want the money to go straight to the people who are supposed to benefit from it instead of it having to go through probate. Because in this case, they had to pay my legal fees, they had to pay the court fees, and they had to pay fees to locate heirs because all of that wasn't clear. But if you have your will, you get to say, if I end up with any property that I forgot to designate before I died, these are the people I want to get it. And it just makes for a more seamless transfer of assets. So I do encourage that you make sure your beneficiary designations on your life insurance, your retirement benefits, and all those things are up to date, because you don't want those assets to get caught in your estate if they don't have to be caught up in there. I talked about an executor. So I want to just kind of make a distinction here between an executor and an administrator. An executor is someone who is over your will. If you have a will, they're the person who is responsible for carrying out the terms of your will. If you do not have a will, that person who carries out that role would be called an administrator. So that's something to keep in mind, that an executor is the name for someone under a will, and the administrator is the name for someone when there was no will. And the reason why I point that out is just there can be a lot of confusion about, okay, well, are they an executor? Are they an administrator? What are their powers? When it comes to the executor, their powers are whatever the will gives them power to do. And administrators' powers are going to fall under state law. And so that's why it's important to have a will, because you can pretty much change the law in a sense in terms of how your estate representative can operate. If you have a will, you can waive their bond. You can say, I'm going to let you serve as executor without having to pay a bond. A bond is pretty much like a life insurance policy where you have to pay it in order to ensure that you won't steal all of the assets of the estate. But if you're creating your will, you're picking someone you trust, and you might say, I trust this person, they don't need a bond, and that saves the estate some cost. You might also say that this executor has the power to sell the property if there's any property in the estate, and you can give them all kinds of powers to not have to file reports to the court, to not have to file an inventory with the court, to not have to provide annual statements to the heirs. You can waive all of those requirements and make the job for your executor a lot easier. But when you don't have a will in place, or if your will does not cover those items, then your representative will have to go through a lot more hoops. And I can tell you on behalf of many of my clients who have had to do those extra hoops, they wish that they didn't have to, because filing an inventory and an annual return for the estate every year is something you got to take time out of your day to do. You might have to hire a lawyer to help you. You have to pay the filing fees to the court. You got to go to the bank and pull all these statements and document all of the transactions that you made on the estate. And it's just a lot more work for the state representative when they don't have those powers waived. So that's a good reason to have a will and to nominate an executor and to waive certain responsibilities for the executor so their job is a little easier. I always tell people, select someone that you trust who's going to be responsible. Don't just select your best friend or your oldest child or somebody that you owe some money to or whatever. Don't do that. You want to choose someone who's going to be the right person for the job. Their role is to go in there and pay off debts that the decedent may have owned. The person whose estate they're dealing with, they're paying their debts. They're distributing any assets to the beneficiaries, and they're representing the interests of the estate in any court proceedings. In addition, they are carrying on any business of the deceased person until those responsibilities can be given to someone else permanently. And I want to make it clear that I'm not saying that the executors personally responsible for taking money out of their pocket to pay the debts of the decedent. Whatever the decedent had in their estate, that is used to pay the debts of the estate, not the personal assets of that executor. So, in case anybody was wondering, you're not responsible for paying for the estate's debts. Um, and another thing that's interesting that comes up a lot that people don't really think about, I've had a lot of cases where the deceased person didn't have very many assets. In fact, they may have been what you would consider indigent, where they had no money, no property, and they would not have thought that they needed a will or any kind of estate planning, but they were a victim of a crime, or they were involved in an accident, or some kind of injury occurred that resulted in their death. And now their family is entitled to some kind of financial payout, but they can't receive that money because there's no one over the estate. And so having a will is helpful in that situation, that you can have your family, hopefully none of us are ever involved in that kind of situation, but it's important for people to know that having a will can be helpful even when someone doesn't own any property, because it just will make the process a lot easier for their loved one in the event that something was discovered after they died that they were not aware of. I had a case where one of my clients had a relative who they died with nothing in their name, but shortly after they died, someone else died and left them some life insurance money. So instead of that money going to the person, or it actually happened right before they died, that they were the beneficiary of a life insurance payout. And because there was no one over their estate, we had to appoint someone in order to receive that life insurance money and distribute it to the heirs. So there's a lot that could happen that is unexpected, that having a will in place, even if it's a very simple will, can be very helpful to make things easier. I know I spent a lot of time on that, but I hope that was a helpful discussion. Um, if you have any additional questions about that, please let me know in the chat, or just a comment, like let me know y'all here and awake, and that I'm not boring y'all. One thing that's important to know about having a will is that probate is required. Some people want to avoid probate, and so they will go the route of creating the trust. But if you do have a will, then your loved ones are going to have to probate your estate, probate that will, in order for the executor to be legally appointed and for the property listed in the will to be transferred to the people who are supposed to receive that property. So that's something that's very important to note, that probate is still required even if you have a will. So I talked a little bit about trust. I mentioned that earlier. Excuse me. That's a way that people can avoid probate if they don't want to have their family go through the probate process. With the will, probate is required. With the trust, then you basically create your own world where probate is not required and assets can be transferred to the heirs directly. Thank y'all for y'all's feedback on the presentation so far. So trust. A lot of people are talking about trust these days. They're like the hot topic on social media, which is exciting to me. I'm like, people are excited about estate planning. So if y'all have questions about trust, please let me know in the chat, because I would love to address any questions or concerns or any misconceptions that people may have while we're in this setting today. But we'll talk generally about them. If I can get my slide to move. Okay. So the question, what is a trust? A trust is a legal arrangement in which one party takes responsibility for property or money and manages it for the benefit of one or more other parties. So I have a little diagram that illustrates it on the next slide. But I do want to tell you that there are many types of trust. And this is something that's very important to note because, like I said, everybody's talking about trust and they're telling people you need a trust, you need a trust. But they don't say that there are so many types of trust that it's impossible to just say, I need a trust. Can you get me a trust? You got to know what your goals are, what you're trying to accomplish with that trust. So there are two main types. The first type is revocable trust. The second type is an irrevocable trust. Those are the two main categories. And within those categories, there are just any range of different types of trust that have different purposes. Some of those may be special needs trusts, which is one that's created for someone who has a disability and is unable to manage their own, the main thing is that they receive public benefits that are dependent on your income, and the person giving them some money in this trust, they don't want to disrupt those public benefits, but at the same time they still want to give them something. So you might create a special needs trust to bless that person who has a disability and receives public benefits, but at the same time you don't want to disrupt those benefits. There are charitable trusts, which are trusts that people use for tax planning purposes. Um, these days, the average person is not really dealing with charitable trusts. They're more so for people with really high net worth estates, but I like to mention them because they are a type of trust. There are inter vivos trusts, which are trusts that are created while a person is living, even though it may not become effective until reverse that. An inter vivos trust is a trust that's created while a person is living versus a testamentary trust, which is only created after a person has died. So you would create the language that says, if these circumstances happen, then a trust is created. That's the situation I talked about earlier, where you might have a minor child and you don't know if they're going to still be a minor when you pass away. So you want to create a testamentary trust that says, if they're still a minor, then this trust will be created. But if not, they can get the property outright. Or if they are disabled, then this trust will be created. But if they're not, then they will get the property outright. And there's other types I'm gonna go into in a few minutes as well, but that's just like a little preview. So this is the diagram of how a trust works. You have trust property. You have it might be money, it might be real property like a house or land, and you have the grantor or the trustor, who's the person that owns the property. So this is my money, this is my house, and I wanted to put it in a trust. So what you do is create a legal document that shows how the property is going to be handled in a trust. It outlines the rules of how the trust operates, who's in charge, what's supposed to happen under various circumstances, and it dictates how the trust is supposed to operate. The grantor or the trustor puts the property into the trust, which means that they put it in the hands of a trustee. The trustee is a person whose job it is to protect those assets, manage those assets, make sure that they are available for the beneficiaries. And so I have those here. The beneficiaries are the people that you want to benefit from the assets in the trust. So the trustee's job is to make sure this property is protected so that the beneficiaries can utilize it. Now, when we use trust in general estate planning, it's usually going to be a revocable trust, and that's like a substitute for a will. So as I mentioned before, with the will, the document says this is how my property is to be transferred. These are the people I'm transferring the property to. These are the people who are in charge of making sure that happens properly. But in order for all those things to happen, probate must happen. You have to take a petition to probate court, take the will to probate court, and have the court basically bless the will and put everything into motion. With the trust, specifically a revocable trust that can be a substitute for the will, you create this trust and then you put your property into it. And the trust now owns and manages the property. But after you die, then the property automatically is going to be transferred according to the terms of that trust. And there are different ways that the property can be transferred. It can be given to your beneficiaries outright, or it can be given to them in another trust that's created, or it can be given to them in phases so that they get a portion at a time, and then until all of the resources are used up. So that's generally how a trust works. There's something I wanted to mention about the revocable trust. The one thing to keep in mind is that the revocable trust can be changed or modified while the person who created it is still living. So they can create that revocable trust. Let's say they say, okay, I have a house, I have money, I want it to go to my 3 children. And then at some point they realize, oh, I'm having 2 more children. So I want to change that trust so that now the property goes to my 5 children, but it's still housed in that trust structure. So you can change it, or you can say, you know what, I don't want this trust. I want to do something different and revoke it altogether. So that's what makes it revocable. Another thing about a revocable trust is that a lot of times the person who puts the property into the trust, who's the trustor or the grantor, they're the same person as the trustee, and they're the same person as the beneficiaries while they're living. After they die, of course, they're not going to be the trustee. So a new trustee comes into play, and they're going to be new beneficiaries as well. But while they're living, so that the property in the trust is still their property, then they would be the trustee, the beneficiary, and the grantor who put the property into the trust. So that's just like some high level information about how trusts work. Um, I see some questions in the chat. I'm just kind of looking at here. Somebody asked if I had any books that they recommend that I recommend about estate planning. So I don't have any that I recommend offhand, but I'm going to send a recap email after this webinar. I know of one particularly that I can put in there as a recommendation. I can't remember the name of it right now. But this is actually something that I want to do one day, is write a book on this to make it very plain language. But if I think of any others, I will put that in the email as well. I'm just kind of glancing at the chat to see if there's any other questions that would be helpful. So I'm going to talk about some reasons why you might include a trust in an estate plan, and then I'm going to try to address some of the other questions that were in the chat. I'm hoping that I can kind of explain things to put it in better context so that everyone knows exactly how to utilize this information. So there are various reasons why someone might put a trust in their estate, might include a trust in their estate plan versus just having a will. Privacy. So when you have a will, it goes through probate court after the person who created the will, after they die, the will goes through probate court and it becomes a public document. Anybody can access it. In fact, a lot of times people are looking in the probate court records to see who's filing wills so they can reach out to the executor and try to buy the property, or creditors might be looking to see, this person owes me money, I'm trying to see if anybody's leaving them some property. So people are watching the probate court documents, filings, and then so a will is a public document once it's probated. However, a trust is something that's private. It's something that only the trustee has and maybe the beneficiaries. And if anybody else wants information about the trust, then they might get specific portions if it's relevant to them, but they don't get the whole trust. So it's not just anybody who wants it can get it. If there is a need for it, there might have to be a whole court process started in order to get a copy of the trust. But even in that kind of situation, the trust will have certain protections so that anybody can't just come and get this trust. So some people want it for privacy purposes. I once had a client who was leaving a decent amount of money to some like nieces and nephews, and he didn't want everybody to know I left my nephew $100,000. So we wanted to create a more private situation where this stuff would not just be public record. Also, if you have minor disabled beneficiaries, I kind of touched on that. You don't want to leave it to them outright. because then a conservator has to be appointed to manage their assets. So in that case, you want to leave it to them in a trust so that a trustee is appointed and that person has the legal authority to manage the property on behalf of that minor or disabled beneficiary, either until they're at a position that they can handle it on their own or indefinitely, if that person is not expected to become independent. Spendthrift beneficiaries, these are people who should be old enough to handle their own property, but maybe they have a lot of debts out there. They're real excited about using whatever money they can get and spending it on something. So you might say, okay, I love my son. Well, I'm not gonna pick on the man. I love my daughter, but she loves everybody. And anytime you give her money, she's gonna spend it on her friends. And I don't want her doing that. So you might create a trust so that the trustee says, okay, so and so, this money is for your rent. I'm giving you $600 to go toward your rent this month. I'm not giving you money to spend on whatever you want to spend it on. Because sometimes people might take a little more time to grow up, and they're whoever's leaving something to them would want to put it in a trust. Asset protection, this is going to be more of an irrevocable trust, and it's for people who may be in high risk professions and they don't want to put their personal property at risk. So let's say that they own the family land, that their granddaddy left them some land, and they also are a surgeon, and it's just expected that there might be some potential malpractice claims or some kind of a lawsuit, and they don't want to put granddaddy's house or granddaddy's farm at risk. And so they might put it into an asset protection trust to protect it from lawsuits or anything that might occur related to their profession. Of course, with this kind of trust, there's a lot of rules that you have to make sure that you follow, or those assets could be put at risk. And so there are some particular things you have to put in place to make sure that those assets are protected. For these days, it's not as much of an issue, but death tax planning or estate tax planning, people would want to avoid having their family members to pay extremely high taxes on their estates if they passed away and had significant assets. Most people don't have to deal with this right now because the limit is very high. It's like $12 million per person. And if you're a married couple, it's $24 million. And so the average person does not fall in that category. So death tax planning is not as common now. However, it is expected that number will go down. And so more people might need to do some estate tax planning or death tax planning, as well as gift tax planning, which I didn't put on here. But once your estate gets above a certain amount, then you will want to talk with your attorney about getting those things done. If you have multiple people owning property together, you might consider putting it into a trust. For example, if it's family property and you want to hold it for the benefit of all of the family, but you don't want any one person's estate getting involved in the property, then you might put in a trust. And then finally, having that automatic transfer of property upon a person's death or their disability without having to go through probate court or any other legal process. That's another reason why someone might create a trust. So let me see what I have next on here. So I'm going to just talk a little bit more about trust and some of the questions that have been put in the chat. For example, some people have asked, like, where do I start? How do I even decide what's best for me? I think that was the question. This is a conversation that is good to have on a one-on-one consultation with an attorney. And I will be offering information on how to schedule a free clarity call with me, which is a free consultation. And we can talk one-on-one about your estate planning needs, whether a will would be appropriate, a trust, what types of trust you might consider. There are a lot of factors that would go into whether or not we consider different types of trusts. I actually forgot to put on this list. Another reason to include a trust is for Medicaid planning or long-term care planning. These days, a lot of people are looking into trusts to help them with long-term care planning. In that case, it would be an irrevocable trust. And the goal of that irrevocable trust is to take all of the property out of your personal name so that when it comes time for you to look into resources for um, long-term care, such as Medicaid to pay for nursing home expenses or Medicaid to pay for someone to come home and take care of you if you got sick in your older years and you needed some extra care, medical care, then in that case, Medicaid is going to look at your personal income and your assets, the how much property do you own. And in that case, some people will say, well, I know I don't have the money in my own pocket to pay for long-term care if I needed it. If I needed to go to a nursing home, I know I don't have the resources for that. So I need to take advantage of something like Medicaid. But I know that even though I can't personally afford a nursing home, I know that I own too much property to qualify for it. And so having what do we call it? A Medicaid trust can be something that you set up to take those assets out of your name so that you still have the use of those assets, but they're not prohibiting you from being eligible for Medicaid to pay for nursing home care. And that's something that it can have its own webinar, and I probably will do one pretty soon, or a YouTube video on long-term care planning. But it's something that's a common reason that people might consider a trust as part of their estate planning. So just looking in the chat, I see a couple of questions that I wanted to address. One person asked, where can trust be filed? And there are some places better than others. So a trust is going to be a document that is maintained with your personal records. And you usually, like if you worked with my firm, we would give you the original documents, which has your ink signature on it. And then we would give you documents that are on an electronic format. We usually send it to you through our client portal. And you can just print copies of those if you needed copies to maybe give to your different trustees. But in terms of storing it, you can store it at your house. Some people keep their important papers in a safe. I would recommend a fireproof, waterproof safe at the house that nobody can get into who doesn't need to get into it. But the people who do need to get into it, they are able to get into it. But some people would consider a safe deposit box. They would put the trust documents or other important documents in a safe deposit box at a bank, which can be a good idea, but you want to make sure that the people who need access to that box, one, know where it is. They know which bank is located at, and that they have the access to that safe deposit box. Because if they don't have access, then they're going to have to go to probate court and file a petition to open the safe deposit box. And we don't want them to have to do that if they don't have to, but it is something that a lot of people end up having to do because someone's like, I'm gonna put my stuff in the safe deposit box, but I'm gonna keep all the keys. And it's like, it just doesn't quite work out that way. So they need to at least make sure that the people who need to have access do have access to those documents into that safe deposit box. And I do see the question about the trust with Fortune 500 companies, and then the question about trust funds versus a trust. Yes, so there is a lot of confusion in general about trust funds versus trust. And I can explain a little bit about how each of those work. So a trust fund is really just funds that are in a trust. And your trust can own anything. It can own bank accounts, it can own houses, it can own land. Your trust can own investment accounts, stocks, bonds, anything. And so what a lot of people will do is if they have a lot of money already, then they'll just put that money into a trust. So you hear the trust fund baby jokes, oh, I'm a trust fund baby. Well, I have a lot of clients who are proud to say that their babies are trust fund babies because they got a trust created for them. They may not have like what the Hilton kids have or some of these celebrities, but they have a trust and it has funds in it. So they have a trust fund. So a trust fund can have $500 in it, or it can have millions of dollars worth of stocks and bonds. And so my babies are trust fund babies. Yeah, represent. So you can have any kind of mutual funds, anything that your trust owns. You would change the ownership of those funds to the trust. And so the trust owns it. And what that does is while you're living, you're able to manage that on your own. It's all fine and good. But if something happens to you where you're not able to manage those funds anymore, you will have a trustee in place who can then take over the management and the ownership and make investment decisions with those funds. So yes, a trust fund and a trust are different, but a trust fund is just the assets that are in the trust. And it could be anything and you can add to it. So someone might create a trust for their child today and they put $500 in it because that's what they have. But then they might they might open up a CD or some kind of investment account. They might buy stocks in the name of the trust and they just add to it. They might buy houses and say, I'm going to put these houses in the ownership of the trust so that that is part of my child's trust fund. And then when the child is old enough to receive those items, then they can either receive it outright or it would just be another trust that is created for the benefit of that child. Even if they are an adult, they'll just have someone else who is managing it for them. One thing that I do want to mention with that is that leaving assets to someone in a trust can protect them against themselves, but it also can protect them against creditors. So you might say, okay, they have a house, they have bank accounts, they have all these things in this trust. Yes, they are fairly responsible individuals, but if they got into a car accident and someone is now trying to sue them for damages or anything that could happen, that those assets are in a trust and they're protected and they're not subject to that liability. So that's another reason why people might put things in a trust rather than giving it to someone outright. I hope that was a helpful little deviation from our topic. I think it was good for me to go through that stuff. So the question of what happens if you die without a solid estate plan? If this happens, then your possessions are going to be distributed to your heirs at law according to state law. A judge decides who takes control or custody of your minor children. A judge would appoint someone to administer your estate, and a judge appoints someone to manage any assets that you leave to children or anybody else who inherits things from you who might need a trustee. And so if you want to be the one in the driver's seat, then it's good to have an estate plan. If you are like the type that likes to leave everything to chance, then having an estate plan is not as important. So I encourage everybody to do some kind of planning. And you might start with the level 1 planning, but then you graduate a little bit as time goes on to more extensive planning as your assets increase, as the needs of your family changes, as your vision expands, then you might expand the type of estate planning that you do to accomplish different goals. I like to encourage people to look at estate planning as a gift. You are leaving a gift to the people you love, you're leaving a gift to your community. And the way that to further expand on this is it's important that you establish goals, that you create an inventory. So your goals, what do you want to accomplish with your estate planning? A lot of people are very focused on when I die, I want my property to go to these people. That's a great goal to have. But then you might think a little bit further. I have a client who she said that, after she attended one of my workshops, she realized that she actually could teach her children about financial literacy through creating an estate plan because she's putting certain levels of responsibility on them at different phases and leaving them certain assets with clear instructions. And so it's teaching her kids about wealth management, about having a mindset of generating wealth and preserving wealth and transferring it to the next generation. So she's not only passing on assets, she's also passing on values. You also want to create an inventory. You want to know what you own so that you can properly plan for those assets. Next, you want to select your fiduciaries. Those are the people who are over your plan. Those are going to be your executors, your trustees, your agents for your power of attorney, your healthcare directive, whoever is going to be in charge of making sure your wishes are carried out those are your fiduciaries. And all of these things are topics that you would talk with your attorney about during the estate planning process. And finally, you want to assemble your team of advisors, the people who will be responsible for advising you about how to structure things. You want to assemble that team before you start the estate planning process. I actually just talked to a financial advisor earlier today, and he and I are going to be presenting with a CPA at the end of this week on the different topics that all intersect: financial planning, estate planning, and tax planning. We're going to be talking with a particular group about these topics because you need a team. Like, don't ask me about taxes, don't ask me about financial planning. I'm your estate planning lady, and they will tell you about the other stuff. So you want to approach this from a team perspective and have the right people in the right seats. And so I had a little more detail here. If you've been on a webinar with me before, you know that I talk too much at the beginning and I run out of time at the end. But I think I covered most everything that needs to be covered. Again, we'll send out the slides later, and you can follow us on YouTube, The Family Land Lawyer. Check it out, and we have plenty of videos there. I do create videos upon request. So if you want me to cover a topic in depth, I will do a YouTube video on it as long as it's in my wheelhouse. If it's not, I will direct you to someone who can do a better video than I can. Again, it's encouraging people to see estate planning as a gift for their family, for their community, and for themselves, because it really does something to you when you are thinking each day that I'm building something, I'm creating something, I'm leaving a legacy, versus just getting up and just going about the day. When you have that intention that I'm doing this for my family, I'm doing it for my community, I'm creating a better life for myself, then it just causes you to approach life in a more intentional way. The question, can I do it myself? Of course you can. There are lots of resources online that people are using these days to do their own planning. There's resources at Office Depot, Staples. You can find those resources, but I just don't advise it because there's so many pitfalls of estate planning that people fall into because they don't talk with an attorney, and I end up still getting involved on the back end. So I do encourage people to talk to an attorney. I've had situations where someone received assets they weren't aware of, and the administration process was drawn out. We thought we were just dealing with a house. Next thing you know, we're in here dealing with other assets that were discovered during the process, and now it's just more complicated because there was no will in place. Situations where someone, and this happens a lot, which is so unfortunate, they'll go to an attorney, they'll create a trust, but they don't fund the trust, which means that they don't put the property into the trust during their lifetime. And so when they die, their family still has to go through probate. I had a situation where things weren't worked out so well, and I'm so grateful, but it was going to be a case where a surviving spouse was entitled to receive the family land. And the spouse, the one who died, he had family land. He was a partial owner of heirs property in this family land. When he died, his property was never put into his trust before he died. So when he died, this became part of his estate. His surviving spouse was going to be entitled to everything, but we were able to work things out so that the family was still able to keep this family land. But we did have to go through a few hoops and put out some money in order to get it done. We had situations where trusts were created, funded, but the instructions are not clear. So then we're in litigation trying to figure out how is this property going to be distributed. But this is, sometimes what happens when people are DIYing because they don't know all the different parts of what's involved in the process. And so I encourage people to hire an attorney to help them with their estate planning, but not just the attorney that you went to school with. I have dealt with those too. I have a case now where someone had their friend who's like a criminal law attorney do a will for them because they just were friends. And now we're in a mess because that criminal law attorney, they know the basics, but they don't know all of the details of what goes into estate planning and what pitfalls to avoid. So I always encourage people, get an estate planning attorney. And also, not just any estate planning attorney, make sure they understand your specific needs. If you have retirement benefits, if you have family members with special needs, if you need long-term care planning, if you have family land, heirs property, if you have succession planning for a business, or if you have land, you want to have a lawyer who understands these topics, and also someone who understands and appreciates your personal, familial, and cultural values. Different cultures see property different ways. This could be racial differences, this can be geographical differences. Thinking about it, like someone who is in New York City, they may not know how to help a family farm owner plan for passing their family farm to the next generation. So you want to make sure that you have someone who understands your particular circumstances when you're hiring an attorney. The pitfalls we want to avoid: we don't want to unintentionally create heirs property. We don't want to say my house goes to my 5 kids with no instructions, because that's just setting it up to become blighted property. We don't want to fail to plan for medical or long-term care expenses. We want to make sure that we have the resources to pay for care if we need it in the future. We want to plan for estate taxes, gifting taxes, retirement benefits, and we want to avoid not hiring the right professionals. So I have here just like a few setups of different plans that we have. There are other plans that are available that we can discuss with you, but just generally speaking, we have trust-based plans and we have will-based plans. And it just depends. Some people will start with the will-based plan, and then one day they'll decide to I guess you could say, upgrade to a trust-based plan. Or some people, I had a client who was in his 90s and it just didn't make sense to create a trust. We did a will, and I think everything is going to go fine. But for someone who is in the building phase and they're still acquiring additional assets, they might consider a trust because they can continue to add things into that trust as their life evolves. So these are the different plans that we have, and we always include a healthcare directive, a financial power of attorney with our plans, because we believe that the assets that you have now are best protected for the people in the future when you have healthcare directives and financial power of attorney paired with those documents. So the process of working with us, I just kind of outlined it here to break it down. I think someone asked earlier in the comments, where do I start? How do I decide for myself what to do with our firm? And we try to break the process down for you in very clear steps, and we walk you through the process. I have a team. It's me. I have a client success coordinator. I have a paralegal, and we all work together to make sure that you know exactly what's going on with the process, that you're comfortable, that we answer any questions. And it starts with a clarity call, which I have a screen on the next slide where you can scan the QR code and schedule a free 30-minute clarity call. That's when you and I will talk about your estate planning goals, what you're wanting to accomplish, any concerns that you have, and then we'll recommend the kind of plan that we think that would benefit you. And we will send this webinar link out to you. And it's for people who participated in this webinar, but if you have a friend that you want to share it with, I would not be upset if you share it with them. In fact, we actually will put it on YouTube at some point. So feel free to share the information if you get it and feel like it would be helpful to someone else. So once we schedule that clarity call and you and I have a one-on-one conversation, if you have a spouse, I encourage you to bring your spouse to the conversation or as early as possible. I've had situations where spouses were brought in later and it didn't end well. So let's make sure we get our partners involved early on so that we can resolve any potential issues up front. You'll complete an intake form where we'll get a lot of information about you, the people in your life, and the property that you own, and we'll help you to select the plan that's right for you. Once we select that plan, we will design that plan. We'll outline who's going to be in charge of what different things will happen at different phases of time. And then we'll have a meeting where you and I will review your documents together and make sure that if you have any questions or anything needs to be changed, that we can handle that before we get to the signing day. And signing day is when we will help you to sign your plan and get everything put in place. And I forgot to mention the funding process because of the bad experiences that I had before where trusts were created but not funded. My firm does assist with the funding process. We want to make sure you get those assets put into the trust so that your family can avoid probate if at all possible, if you've created a trust. If you haven't created a trust, then we will complete the process at the signing point where we will sign your will and your other documents. But we try to be a very supportive process because we know for many of our clients, this is the first time that they've done anything like this and they have a lot of questions. They might be unsure. And our goal is to handhold through the process. Thank you so much for watching today. I hope that you enjoyed it and learned something. Make sure that you subscribe, like this video, share it with a friend, leave a comment. I would love to hear what you thought. And if you have any questions or anything else that you want to cover, let me know and I'll make sure to cover it in one of my upcoming videos. Again, this is Veronica McClendon, the family land lawyer, owner of McClendon Law and Consulting, the family land law firm. Take care.